seminar today, delivered by our very own Steve Hurley. Now, those of you and the School of Law will know Steve as a principal lecturer in employment and equality law. Steve is the module lead for contract law, disability law, and employment law. Steve is currently doing a PhD at Oxford Brookes University, and his research promises to actually really inform the debate about philosophical beliefs and equality. So we are very lucky to have Steve talking to us today about, is a fear of catching COVID-19 a legally protected philosophical belief? Should it be? So Steve, thank you very much, and thank you for giving up, and thank you for those attending. Before Steve begins, what I'd like to say as well, if you are interested in attending any research seminars or listen to recordings, these are available for you to watch. And if students are interested in presenting on their own research, especially in the final year on the dissertation research, that's something we also very much welcome as well. So Steve, good afternoon and thank you very much.
Thanks a lot, Chris. Thanks for that. I feel in illustrious company with those other speakers that you mentioned. So hopefully I will kind of finish off this research seminar series the same standard, hopefully. Right, thank you for coming, everybody. Thank you for people listening at home, people that might be viewing the recording later on. I'll just see if I can get these slides up. So I've got a few slides to guide us through what I propose to talk about today. So my topic really is, as on the screen, is a fear of catching COVID-19 a protected philosophical belief, and should it be? And we've probably all got views about should it be. Maybe they will change after the research seminar, give you a few more factors to think about before you make your decision. As Chris has kindly mentioned, I'm currently doing a part-time PhD at Oxford Brookes, and I'm looking at the legal protection of philosophical belief in the workplace, in particular under the Equality Act 2010. So that's the focus. And some of you may have attended one or two other research seminars where I've touched upon other bits of case law to do with philosophical belief. So if you've heard any of this before, please see it as a refresher, a reminder, but I'm not assuming any prior knowledge. And there will be things in here that you haven't heard, certainly not from me anyway. So let's have a think about this. And first of all, give you a few quick health warnings. There's the legal one. So again, I'm not advising somebody here to give to not attend work, to attend work. I am a solicitor, but this is purely for educational benefit, not for legal advice. So don't do anything on the back of what I'm telling you now. Also, I thought it's appropriate here to have a health warning, because again, we're talking about medical matters really and scientific matters with COVID-19. And for the avoidance of doubt, I don't know anything about the science or the medicine side of COVID-19, so please look elsewhere for your thoughts about that. But what I'm looking at is the legal side of it, and in particular from the point of view of employees and their rights. So that's my kind of angle. So with those kind of health warnings given, what's the focus of this presentation? Well, basically, it's coming back to the initial question, which begs a lot of other questions, as we'll see, of what is a philosophical belief for the purposes of the Equality Act 2010. And this legislation has been around for quite a few number of years now. And you might think, well, surely by now they would have figured out what a philosophical belief is. Well, there are certainly some guidelines that have appeared. But due to the nature of how philosophical belief is defined and decided, which we'll look at in a moment under the Equality Act, there is almost certainly going to always be an element of ambiguity and doubt as to whether or not a particular belief that somebody holds is or is not protected by the Act. And that in itself is a criticism that certainly I'm planning to make in my kind of ultimate PhD thesis. The lack of ambiguity here is a definite downside for the law. On the upside, there is an upside in that what this does mean is that the law can adapt very quickly to changing circumstances. So again, the number of cases on philosophical belief have accelerated over the last few years, partly because publicity has been given to key cases like the ethical vegan case, for instance, um, and partly because lawyers are getting more familiar with this area and they're trying to use this part of the Equality Act to put forward arguments on behalf of their clients, which obviously is entirely appropriate. So this is an area to watch. I think it's an area that's going to grow, but it does still leave us with that initial question: what's protected and what isn't? Because it's rather important that we know what's protected and what isn't. And one of the points that I'll be making as well is that the law currently is not really suitable for the protection that it's being offered, and we need to really rethink how philosophical beliefs are protected in the workplace. Because at the moment, arguably, they're not protected that well. So those are kind of the key issues that we're going to think about. In particular, we're going to think about COVID-19 and beliefs about COVID-19, and we're going to think about it from the point of view of protection under the Equality Act 2010, because it's important to realise that I've read recently there are about 2,500 cases now that mention or touch upon COVID-19 having gone through the tribunal system. So there's a growing body of case law in relation to COVID-19. Lots of those cases will be to do with whether somebody should have got a furlough payment, whether somebody made redundant during the pandemic was made redundant fairly or not. And also quite a few cases are to do with whether or not it was appropriate to dismiss somebody. So for instance, if they refused to get a vaccination, or if they were concerned about returning to the workplace due to a fear of catching COVID. And those cases are not discrimination cases, they are in particular unfair dismissal cases. And you'll see if you kind of look around this area generally, there's quite detailed protection, if slightly complicatedly worded, in section 100 of the Employment Rights Act 1996, which makes it automatically unfair to dismiss individuals for various health and safety related matters, including raising health and safety concerns in the workplace. And on top of this, an employer still needs to remember that every employee is protected by their contract of employment. So regardless of the answer to the question that I've posed in this research seminar, whether or not a fear of catching COVID is protected under equality law, an employer would still need to act reasonably in responding to and dealing with an employee who had a genuine fear of catching COVID. Or else, if nothing else, that the employer could be at risk of being in breach of the implied term of trust and confidence, potentially in extreme cases entitling the employee to resign and claim constructive dismissal. So there's a lot of law around the edges of this question, but today we're just going to focus upon one particular type of law, which is the Equality Act 2010. And in particular, we're going to look at a recent case where this question was actually addressed by the tribunal up in Manchester. I'm going to see what they made of it, and we're going to see what we make of the tribunal's reasoning. So let's first of all set the scene, shall we? The scene here is we're in the Equality Act 2010. As a lot of people listening to this will know, this is where you will pretty much find most of UK discrimination law now consolidated. And the way that act works is to provide protection largely framed around what are called protected characteristics. And these are things including, say, sex, race, disability, sexual orientation, age, a collection of different protected characteristics. The one that we're interested in today's seminar is religion or belief. And it's section 10 where we get guidance in the Act about the meaning of that phrase. I'll just give us the brief definition of belief in the Act in section 10, subsection 2. Belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. And that final part of section 10, subsection 2 is also something that we should bear in mind throughout the course of this seminar, because it really does have a practical impact upon the consequences of deciding that a certain belief is protected. It may have unforeseen consequences. So we'll come back to these issues a bit later in the seminar. But first of all, I thought it would be useful, especially for anybody who hasn't studied the Equality Act before and UK discrimination law, just to ask ourselves why it matters. Why are we bothered whether or not a certain belief is or is not protected under the Act? So I just thought I'd put down a few immediate thoughts about why it is an important question. The way that the Equality Act works is if you do fall within one of the protected characteristics definitions, then it unlocks a whole set of legal goodies for you. And those legal goodies are benefits to you, but they also impose burdens on other people, such as employers, schools, hospitals, universities, shops, etc. So it matters who can unlock this protection and who can't. If you are able to fit yourself into one of the protected characteristics, then you benefit from a number of legal duties. You benefit from protection from direct discrimination, so less favourable treatment because of that protected characteristic. Indirect discrimination, where essentially one rule is applied to everybody, but certain people in society struggle more to comply with that rule. And also you get protection from harassment as well, more direct protection from harassment than you would if you didn't have a protected characteristic. Most importantly, if you qualify, you get unlimited compensation. So there is no artificial cap placed by Parliament on the damages that you can recover if you are a victim of unlawful discrimination under the Equality Act. And even though most claims don't get beyond the kind of the low thousands, you do get some claims that are in the high, £2, £3, £4 million is reported every now and again. So the size of compensation is a key factor for many people, including employers. You can sue for injury to your feelings if you can put yourself into one of the protected characteristics and win your claim. And also in relation to discrimination, there is perhaps a greater public shame by employers in a finding of being guilty of discrimination that isn't there typically if an employer is found guilty of unfairly dismissing somebody or wrongfully dismissing them. They may still feel a bit guilty about that, but they normally fear a finding of discrimination much more. Most importantly, you don't need any particular length of service as an employee. So if you are suing for unfair dismissal, you need to be an employee. You normally need 2 years service, so there are some exceptions. For the Equality Act, you don't need to be an employee. So you could be a kind of a casual worker, a gig economy worker. You can still get protected. You can still sue. And also you don't need to have worked for any particular length of time for that employer. The rights also extend beyond the workplace, because if you can fit yourself into one of the protected characteristics in the Equality Act, the Equality Act doesn't apply just to the workplace. So it would apply in all of those other venues that I've mentioned, where people are providing with education or with goods, facilities or services or transport. And the final point why it matters who falls within and who doesn't fall within the protected characteristic of religion or belief is the particular way in which the Equality Act has set up religion or belief as a protected characteristic. And you'll recall the way it's set up is that if you hold the particular philosophical belief that is held to be protected by the law, you are protected from less favourable treatment because you hold that belief. But also, people that don't hold your belief are also protected from less favourable treatment if they receive the less favourable treatment because they did not hold the belief that you hold. So in this context, for instance, if the law is that a fear of catching COVID-19 is a protected philosophical belief, and we'll see to the conclusion that the Manchester Tribunal came to in a moment, but if that was the conclusion of the tribunal, then that would also provide legal rights to people who didn't think that COVID-19 was a risky thing and didn't have any fear of catching it. In particular, that may have consequences for employers if they adopt an approach of trying to set rules for employees as regards social distancing, mask wearing, self-isolation, test. If somebody holds a protected philosophical belief that they don't fear COVID, then requiring them to take such preventative steps may lead the employer into legal difficulty, because the person who doesn't fear COVID may then have an argument that their protected philosophical belief is being inappropriately respected by the employer. So, in short, it matters. it matters enormously what is protected by the Equality Act, and in particular, what falls within this category of protected philosophical belief. So, hopefully, I persuaded you that it matters. How then does the law currently in the UK figure out whether or not you've got a philosophical belief that is protected? Well, the Act itself, as we saw a moment ago, the Equality Act 2010, doesn't really give you that much guidance, doesn't really expand the definition that much. There is a code of practice on employment produced by the Equality and Human Rights Commission and approved by Parliament, which provides a little bit more guidance, but not much. Again, bearing in mind the case law, insofar as it's relevant for us today, the code of practice says that a belief must affect how a person lives their life or perceives the world. I should mention that we're not in this research seminar focusing upon religion. We're focusing upon the belief word, which is said to include both religious belief, again, which we're not concerned with in today's seminar, and also philosophical belief, which we are concerned with in today's seminar. So in those philosophical belief cases, to be legally protected, your belief must affect how you live your life or perceive the world, says the code of practice. Now, ultimately, that question is for a court or a tribunal to decide. And you may already know that the UK is still a signatory to the European Convention of Human Rights, notwithstanding the present UK government's proposals to reform human rights law. I understand, though I know Josie is in the audience, she'll correct me if I'm wrong, that the UK government is not currently proposing to remove the UK from being a signatory to the European Convention or being a member of the Council of Europe. But the UK government is proposing amending human rights law in the UK. But at the moment, the UK tribunals have to basically take the convention into account. In particular, Article 9 is very relevant here. Article 9 of the convention protects you as regards your freedom of thought, conscience, and religion. So this is a little bit of a kind of a starter in terms of how the law decides whether a belief that you hold should get all of those legal protections that I spoke about a moment ago. The key case, though, and I've mentioned this before in some other seminars, so forgive me if you've heard this before from me. The key foundational case is the case of Granger PLC and Nicholson, 2010. Mr. Nicholson held a fundamental belief, a sincerely held belief in man-made climate change. This impacted every way in which he lived his life, and the tribunal had to decide, and ultimately it was the Employment Appeal Tribunal where appeals go. They had to decide whether or not his belief in man-made climate change satisfied the legal test for a protected philosophical belief. If it did, then it would open up those protections that I listed a moment ago against direct, indirect discrimination and harassment. If they didn't, then he might still have other rights under his contract or unfair dismissal law, but he wouldn't have rights under the Equality Act. At least not rights that depended upon him holding a protected philosophical belief. So they decided that man-made climate change, in his case, was a protected philosophical belief, and the EAT in the case took the opportunity to basically set out the legal criteria, which are forever known as the Granger criteria, that the tribunals need to apply when deciding whether or not a particular belief being put forward to the tribunal as benefiting from legal protection, whether that particular belief does or does not satisfy the legal test to be a protected philosophical belief under the Equality Act 2010. So what are the criteria? Again, this is not statute law. This is not an act of a regulation or an act of parliament. This is a summary by a judge based upon lots of other cases and also references to the European Convention on Human Rights and other things. So to be protected, your belief needs to be genuinely held. So if you don't genuinely hold the belief yourself, you can't piggyback on other people's beliefs. You yourself must hold the belief. Secondly, it must be a belief and not an opinion or a viewpoint based upon the present state of information available. We'll come back to that one. That's very relevant for today's seminar. Thirdly, it needs to be a belief as to a weighty and substantial aspect of human life and behaviour. Again, we'll see that's particularly relevant for the case that we'll look at in today's seminar. It needs also to attain what's called a certain level of cogency, seriousness, cohesion, and importance. And the final one, which if you're following this little series of seminars, you might recall I did my last seminar on, is that your belief needs to be worthy of respect in a democratic society, not incompatible with human dignity, and not conflicting with the fundamental rights of other people. So that, in essence, is, or those are the Granger criteria. And I think you'll probably conclude a few things with me on this, hopefully. Firstly, they are quite vaguely worded in places. You wouldn't call them precisely worded. And the second factor to bear in mind is they do leave a rather lot of judgment and discretion to individual tribunals around the country, who are the legal body that decides whether or not, as regards an employee or a worker, the Equality Act 2010 has been breached. And a further point, just in relation to the way tribunals operate, that may also be relevant here, is that most of these cases involve preliminary hearings where the tribunal is not deciding whether or not overall you were or were not discriminated against. What the tribunal has done, they have essentially carved out the initial question of whether or not the belief that you hold is protected at all. And normally they just have a separate hearing on that. And those hearings tend to be just before a single judge, a single employment judge. So again, that does have the effect of a single person deciding whether or not all of those benefits under the Equality Act are to be accorded to the claimant if they hold a certain belief that satisfies a Granger criteria. And naturally, those decisions then may get widespread publicity, and other people who hold those views may also claim that they are also legally protected. So, quite a big introduction there. Let's look at the case in question. So, this is the case that got quite a lot of publicity around kind of Christmas, January time, just gone. And it was exactly on the point that we're looking at today. So we don't know who the parties were. They were anonymised to X and Y. The case was heard as a preliminary hearing up in the Manchester Employment Tribunal in front of a single judge sitting alone, Employment Judge Leach. I've got the decision here in front of me. The claimant was a woman. She was not legally represented. She was representing herself at the hearing. The employer, again, we don't know who the employer was, but they were represented by a barrister. So what happened and what did the Employment Tribunal decide? Well, basically what happened was that on the 31st of July 2020, the claimant decided not to go back to work. And we've got the benefit in the tribunal decision, which is very brief, of actually hearing the claimant's own words, because part of her witness statement was extracted by the employment judge. And the relevant bit I've extracted from the extract is on the screen. She said, "I had a genuine fear of getting the virus myself and passing it on to my partner, who is at high risk of getting seriously unwell from COVID-19. And later on in her witness statement, she said, this was at the start of the second wave of COVID-19 and the huge increase in cases throughout the country." So that's the end of the quote from her witness statement. Now, what happened was, having decided not to go back to work due to her fear of catching the virus and possibly passing it on to her partner as well, she then had her wages for the days that she refused to go to work withheld by the employer. And the general principle is to be eligible for a day's pay. Generally, there are lots of different exceptions, but generally you need to be ready and willing and able to work. So the employer took the view, well, you're refusing to work, therefore why should I pay you for any of those days? She brought a claim in the Manchester Employment Tribunal alleging that she had been a victim of philosophical belief discrimination under the Equality Act 2010. And naturally, what the Employment Tribunal then did was listed it for a separate hearing to decide the rights and wrongs of that argument as to whether or not her belief was or was not a protected philosophical belief. Now, she was asked by the employment judge to specify precisely exactly what her belief was. And I've put the quote from the Employment Tribunal decision at the top of the slide there. She said her belief was a fear of catching COVID-19 and a need to protect myself and others. So that was her belief. That was a belief that the case was all about. Now, what did the Employment Tribunal find? Well, remember that they had to apply those Granger criteria that we looked at earlier. And at first, it looked quite positive for the claimant. The claimant's beliefs were assumed to be genuine for the purposes of the hearing. This is quite normal. The respondent employer reserved its right if it was found to be protected in principle. When it got to the actual merits hearing, it reserved the right to challenge whether or not the claimant's belief in it was genuine by cross-examination and other means. But for the purposes of the preliminary legal hearing, it was agreed by all parties that it will be assumed that the claimant's belief was genuine. So that ticks that box. The judge was happy to conclude that the belief had a certain amount of cogency, seriousness, cohesion, and importance. And again, that's one of the key Granger criteria as well. The point being here that the law doesn't set out to protect things that are not important, that are kind of trivial, that don't really matter. You shouldn't get legal protection for those beliefs. And the third one that went in her favour was that her belief was worthy of respect in a democratic society. And again, that wasn't challenged at all by the employer's representative. However, and you know there is a however coming, you can tell, can't you? Ultimately, her claim failed as regards her belief being protected under the Equality Act. So, why did it fail? Well, it failed because in the view of the employment judge, again, one person trying their best to reach the right decision based upon the evidence and the law, but nevertheless, one person decided that there are two criteria of the Granger criteria that the claimant did not satisfy. The judge was not satisfied that what the claimant believed was actually a belief instead of just an opinion or a viewpoint based on the present state of information available. And secondly, the judge was also not persuaded that the claimant had a belief as to a weighty and substantial aspect of human life and behaviour. So I'll just go through a few of the comments that were made in relation to these particular points. And that will hopefully help us to explain why were those particular criteria not satisfied in the court's view. Now, in relation to whether it's a belief or a viewpoint, this seems to be the main problem that the claimant had getting over the first hurdle. What the judge said was this. I'll read out the paragraph 15 and 16, and then we can have a think about them. So paragraph 15, this is the judge talking. I do not find that the claimant's fear amounts to a belief. Rather, it is a reaction to a threat of physical harm and the need to take steps to avoid or reduce that threat. Most, if not all people, instinctively react to perceived or real threats of physical harm in one way or another. It can also be described as a widely held opinion based on the present state of information available, that taking certain steps, for example, attending a crowded place during the height of the current pandemic, would increase the risk of contracting COVID-19 and may therefore be dangerous. Few people, said the judge, may argue against that. However, a fear of physical harm, going back to the quote I put on the screen, and views about how best to reduce or avoid a risk of physical harm is not a belief for the purposes of Section 10. Now, just go on to the other points. The second point was the criteria failed as regards it being a weighty and substantial aspect of human life and behaviour. Again, the judge talking at paragraph 17. I do not accept that the claimant's fear of contracting COVID-19 amounts to a belief. Fears about the harm being caused by COVID-19 are weighty and substantial. They are certainly not minor or trivial. They are also about aspects of human life and behaviour. However, and this is where it starts to go wrong for the claimant, in her submissions, the barrister for the employer disputed that this criterion was met, in that the claimant's belief was a time-specific reaction to her own concerns. I agree, said the judge, that it is time-specific. in the sense that the fear will only last as long as dangers caused by the current pandemic remain present. Although I do not accept that that factor in itself avoids this criterion being met. I also note that while the claimant did indeed explain her fear in terms of returning to the workplace, I understand her fear to be wider than this, and that it impacts on the claimant's decisions about attending other places. However, I do agree, said the judge, with the barrister for the employer, that it is about the claimant herself, as in the belief is about the claimant herself, and the protection of herself, and her own steps to protect others, principally her partner. The claimant does not rely on a belief in wider terms than this, and for this reason, I find that this criterion is not met. Over the page, the judge confirms paragraph 22, the fear of contracting COVID-19 and the claimant's requirement to take steps to avoid herself and others is, though, serious and important, and the belief is cogent. So the other criteria was met. So what are we to make of those parts of reasoning by the judge? Was the judge making the right decision there or not? There are a number of kind of points that come out of this, really. In relation to the belief must be a belief and not an opinion or viewpoint based on the present state of information available. This is something that has caused quite a bit of confusion in the case law. It derives, I think I've got time very briefly, it derives from a previous case where a justice of the peace basically wanted to be excused from sitting on family law cases where there was a possibility of a child being placed with a same-sex couple for adoption because the magistrate concerned who sat on the family panel did not believe that, based upon the current evidence available to him, that allowing a child to be placed for adoption with a same-sex couple was in the child's best interests. Now, that was his belief. He did not believe that was in the child's best interest, and he made it clear in his case that it was based upon his reading of the current evidence on that matter. But what the court said was, that's just your reading of the evidence. You're just holding an opinion or a viewpoint based upon the present state of information available. That is not a belief within the meaning of Section 10 of the Equality Act. So a belief must, according to the law, be more than simply an opinion or viewpoint based upon the present state of information available. But there is, I think, a big problem here in terms of, well, how do you define a belief if not involving opinions and viewpoints, for instance? If you have a belief about something, surely you have reached a viewpoint. You are holding an opinion. Your belief might be based upon a number of things: how you feel, your reading of evidence, maybe the evidence has got nothing to do with it. Equally, if you think back to the Granger and Nicholson case, where Mr. Nicholson's belief in man-made climate change was certainly influenced in his case by his understanding of the scientific evidence. The fact that it was based upon the present state of information available to Mr. Nicholson didn't prevent, as a matter of law, his belief in climate change being man-made from being protected as a philosophical belief. So the whole issue here about your belief can be protected, but if what you're holding is not a belief within the meaning of the law, it's simply an opinion or a viewpoint based upon the present information, that's not protected. I think that's a very difficult kind of line to draw, to know which side that you're on. At what point does an opinion or a viewpoint become a belief? Very difficult question, that. The separate point I would make is in relation to the weight and substantial aspect of human life and behaviour. Oh, Nick, I'll just have a look at your question first. Do you think it would... Right, hold on there. That's all right, let's have a look at this. Do you think it would have made a difference to the third limit of the test if she had instead claimed she fears spreading COVID to others, perhaps vulnerable people, if she had worked somewhere like a care home, she would believe the same thing about others going back to the office? Possibly. Can I come back to that, Nick? I think that's a really good point. Yeah, hold on to that point. That's a really good point. let me just briefly touch upon the time-specific point as well, because chronologically that comes before the point you're making about the extent of her belief. But very briefly, what the barrister for the employer said is, well, another reason why this can't be a belief as to a weighty and substantial aspect of human life and behaviour is that she's only going to believe it for a certain period of time, as in while the pandemic is on. According to her evidence, she's worried about the pandemic, the extent of the risk. We assume that the pandemic will at some point abate and go away. And therefore, presumably at that point, says the barrister for the company, then the belief goes away. And surely the fact that somebody's holding a belief, again, to use that word in a kind of a neutral sense for the moment, a belief that is time limited, that's got kind of a shelf life to it, surely that isn't the type of belief that the law currently protects. Now, firstly, it's an interesting argument. I don't think I've ever seen it in the other cases, and I've read pretty much all of the other cases at the tribunal level about philosophical belief in the workplace that have been published. So I haven't seen that argument before. So the argument is a very novel one. In fairness to the employment judge refuses to accept that the time limited nature of your belief, as in the fact you may only hold it for a number of weeks or months or maybe a few years, in itself would be enough to prevent it satisfying that criterion of being relating to a weighty and substantial aspect of human life and behaviour. So the judge saw merit in that argument, but wasn't convinced that that alone would be enough to prevent that criterion being accepted. Now, coming back to your point, Nick, which comes on to the other point I was going to make, which is the other criticism of the claimant here was, well, your belief really doesn't extend very much beyond you and your immediate family. Again, they talk about the fact, well, it extends to other decisions that she makes, but the employment decision only refers to decisions that she would make about attending other venues. So not just attending the workplace. And in particular, the judge said it's about the claimant herself and the protection of herself and her own steps to protect others, principally her partner. So that begs a number of questions, and hence your really good question there, Nick. How much wider would her belief have had to span in order for it to span wide enough for the judge to be persuaded that it wasn't kind of too localized a belief? It's a really interesting question. Again, your suggestion is there if she'd had to maybe visit care homes or she worked in a care home, if she believed it wasn't just herself at risk, that might help, absolutely. There are a number of things going on here, and again, if you look at the cases, must be conscious of the time as well to allow time for other questions. Excuse me. But if you look at the case law, there is a confusion here in terms of your belief doesn't need to encompass the whole world. It doesn't need to be a whole world view, and it does not need to be a view that is concerned for everybody who lives on the planet or every animal or spirit who lives on the planet. Certainly cases have been clear that your belief doesn't need to be that all-encompassing as a worldview. If it is all-encompassing as a worldview, again, go back to Mr. Nicholson and climate change. He would clearly argue, well, look, this is completely a worldview. Man-made climate change, in his view, will affect everybody and is affecting everybody on the planet. But the point I'm making is, as a matter of law, your belief does not need to be so wide. But really here, there is a question, well, is this too narrow? Both in terms of the number of people that are affected by your belief or you think should be affected by your belief and maybe should follow your belief. But the other aspect of the case here is how many aspects of the claimant's life needs to be affected by this. So here, if the only aspect of the claimant's life that is affected by the belief is whether or not she goes to a workplace, or even whether or not she goes to a workplace or to the shops or somewhere else, is that enough? How far, in other words, how many areas of your life does the belief have to infiltrate into and affect in order for it to satisfy the Granger criteria on this point. And again, that I think is a very ambiguous point. Also, I think it might be worth, again, just going back to your question, Nick. I do suspect that if the claimant had been legally represented, that she might well have been advised to broaden the scope of her argument, and perhaps completely understandably, if you don't have any legal knowledge behind you, then again, we don't know in fairness what the claimant's job was. She might have been a lawyer for all I know. I don't know what her job was, but I assume that she wasn't. But it could be that if you had a lawyer arguing in court for her, that the lawyer would have been fearful of limiting the scope of the effect of her belief on her life, for the very point that has ended up here in the tribunal decision, that the judge seems to imply that the effect of her belief is too narrow in terms of its impact upon other people and impact on other areas of her life. It's too narrow to justify legal protection. So again, that does raise a question as to how that should be, how that should have been dealt with. So there are a number of points there to think about. What does this decision not mean, before I finally put forward some further questions for us to go away and for as homework? And then very happy to take any comments or questions that people have got in the audience. So let's be clear upon a number of things. Firstly, this is only an employment tribunal decision, so it's only a first instance decision. This decision binds nobody but the parties in the case. So it doesn't have any precedent value. It is interesting, and it's got a lot of publicity, and lots of employers certainly at the time breathed a big sigh of relief when this decision came out, because it would appear to strengthen the hand of employers to require people to come back to work. But again, it's very important to note this case does not set any legal precedent. Somebody else could walk into the Manchester Tribunal tomorrow and claim that they had a fear of catching COVID, and a different employment judge could run through the same Granger criteria based upon different evidence and conclude that that particular claimant's belief was protected. This is how, what should we say, ambiguous and flexible this area of the law is, and unpredictable. So what this decision does not mean, again, firstly, it doesn't bind anybody but the parties in the case. But even in general terms, what messages is it not sending out? It's certainly not sending out any message that all employees' health and safety concerns about COVID-19 can be safely ignored by an employer. That would be absolutely the wrong message to take from this case if you're an employer. Also, what this case does not mean is that all employees can be required to return to their workplace, however reluctant they are due to COVID fears or what have you, to do so. It doesn't mean that at all. An employee whose beliefs about COVID-19 were more developed or comprehensive might have been protected. So again, this case doesn't mean that every claimant, every employee who is concerned about COVID would also lose if they brought their concerns in front of the employment tribunal. It doesn't mean that at all. Each of these cases stands and falls upon the evidence put forward by the claimant and the extent of their argument as to the extent of their belief and the extent to which it satisfies the Granger criteria. And finally, the general point which we kind of came in on, what this case does not mean is that the other rights that employees have, in particular, to be protected from unfair dismissal. I've already talked about the Section 100 Employment Rights Act 1996 protection, automatic unfair dismissal protection in relation to raising health and safety concerns in the workplace. That law is unaffected by this decision, and equally, every employee has a contract of employment with a number of implied rights, maintain trust and confidence, essentially to act not very unreasonably towards an employee. Those rights under the contract still remain. So it'd be a foolish employer that read too much into this case. Just take a gulp of water at this point. So what questions does this case beg? Well, these are some questions that occurred to me. Firstly, should it be relevant whether or not your belief gets legal protection, how long you have or are likely to hold the belief for? And if so, why? Why should that be a relevant factor? Now, you could certainly see some employment judges or employment tribunals thinking, well, if basically you've only held this belief since last Wednesday, maybe that is evidence of a different point, which is that you don't genuinely hold it. And maybe you're only holding it because you've read about it and somebody else has held this belief and been protected, and you've read about it in the newspapers, and now suddenly you've got the belief as well. So it could go to the credibility of the employee, of the claimant perhaps, as to the genuineness of their belief. But in theory, if you genuinely hold a belief from last Wednesday, is that relevant at all to whether your belief should be protected, provided that it satisfies the Granger criteria and you genuinely hold it? Further, the fact that your belief may only last for a few years, again, maybe you think that if we think about international sporting boycotts and things, maybe you believe that certain countries' teams should be boycotted for a certain period of time due to certain actions of those countries. Well, at some point, maybe you're focused upon only one Olympic Games or one World Cup or what have you. So maybe your belief is limited. The fact that it's time limited, should that reduce the legal protection that you get? A further question to think about is, why is the law so concerned to protect beliefs, not concerned to protect, in this context at least, opinions and viewpoints? So if we imagine that the employment tribunal is right, and that in the claimant's case, in X and Y, she had a genuine viewpoint, but not a genuine belief, why should her viewpoint not be protected? So what is it about beliefs that merit protection by the law currently, in a way that viewpoints shouldn't? Is it that there are simply too many viewpoints to protect? The courts will be overloaded. There aren't as many beliefs to protect. Again, I suspect it's slightly more complicated than that. It also begs a question again, what are we trying to protect here as a society? Are we trying to protect philosophical beliefs because people who have held beliefs previously have been subject to discrimination? Or are there other reasons? Are we trying to do it to promote free speech, the free exchange of ideas? Are we trying to make up for historical disadvantage that certain groups in society have suffered? So the case reminds us of the overall question: why are we protecting any philosophical belief at all? What's the point that we're trying to achieve here? What's the mischief of the act on this particular point? The other question I've suggested: can you ever draw a clear distinction between what's a belief and what's an opinion or a viewpoint? It would seem as though legally it's essential that you can draw a clear distinction, because that appears to be the distinction upon which people are winning and losing cases. But as a matter of logic and argument, can you clearly explain to me what is a viewpoint compared to what is a belief? It's a difficult question, I think. How much wider, going back to your point, Nick, how much wider would X's belief have needed to be in order for her to gain protection? If she had given evidence about she's fearful for the health and the welfare of the entire country or the entire world, would that have increased the chances of her belief satisfying Granger and being protected? I suspect it would, based upon the current case law. And again, relating to that, if we accept what the tribunal accepted, that X's beliefs only related to the issue of where she travelled to, where she attended, and they really only related to protecting her and her immediate family, e.g. her partner in particular, are those beliefs not worthy of protection by the law? If they're not worthy of protection, why not? Or is it the case that actually they are worthy of protection and that she shouldn't be docked her pay for basically trying to follow through on those beliefs, but that protecting her by way of allowing such a belief to be a protected philosophical belief is inappropriate? It's over the top. It gives too much protection compared to the risk or the damage that she would be should be at risk of in terms of losing some pay, is what I'm talking about there. So again, that's a question at the end of that. Maybe such a belief should be protected, maybe it shouldn't, but it depends upon a number of things. What society is trying to do at all in protecting philosophical beliefs, and also what the form of that protection is. Maybe a form of unfair dismissal protection would be appropriate, but maybe a form of discrimination protection wouldn't be. Again, I'll just put that forward as something for us to think about. And I think that's all I was proposing to say. So, sorry I've taken quite a long time to say that, but hopefully you found that interesting. Has anyone got any other comments or any questions?